Hello, my name is Emily Hendrickson, and this is my compare and contrast for week 6. This is going to be about will and estate terms. So let's start with will versus estate. For a will, it is a formal legal document that states a testator's wishes and instructions for managing and distributing their estate after death. An example would be, according to her will, Adam will receive his grandmother's house upon her death. An estate is the total property, real and personal, owned by an individual prior to distribution through trust or will. So for this example, the house is the property described. Next we have testate versus intestate. Testate refers to the state of a person who has made a will. So when a person dies testate, it means they had a valid will at the time of their death. An example would be Adam's grandmother wrote a will, meaning that she will die testate. Intestate refers to when a person dies without a valid will. If Adam's grandmother died without writing a will, her estate and property would go through probate court. Next we have guardian versus conservator. A guardian is one who legally has the responsibility over the care and management of the person or person and property who is a minor or someone who is incompetent. If Adam was 12 at the time of his grandmother's death, her estate would likely be placed into the hands of another family member until Adam becomes an adult and is able to manage the inheritance. A conservator, on the other hand, is one who legally has the care and management of the property but not the person, of someone who is incapacitated or has been declared incompetent. If Adam's grandmother did not possess a valid will in her later years and began suffering severe cognitive decline, a court may appoint a conservator to help manage her accounts and property. Next we have the testator versus executor. A testator is a person who makes the will, so Adam's grandmother is the testator of her will. An executor is the personal representative of the estate who is responsible for settling the estate. If Adam was named the executor in his grandmother's will, he would be responsible for managing and settling her estate via paying final bills and taxes, distributing assets to other people in the will, handling legal tasks, etc. Next we have probate assets, which are assets that an individual owns at his death in his sole name, of which do not have a survivorship feature that will control the disposition at death. Adam's grandmother's house, car, and jewelry are examples of probate assets. Non-probate are assets in which the title has already been transferred within a decedent's lifetime, or assets in which the transfer of title is controlled by some sort of survivorship mechanism. So Adam would not be able to access his grandmother's retirement account or life insurance policy unless he was listed as the beneficiary. A revocable trust is a will substitute, meaning that title of assets in the trust is transferred during the lifetime of the donor, even though the benefits of the assets are not enjoyed by the beneficiary until after the death of the donor. It can be revoked by the donor at any time during their lifetime. An example would be a couple creates a revocable living trust to manage their home, investments, and bank accounts, ensuring assets automatically transfer to the surviving spouse after one spouse dies. After the second spouse dies, all assets transfer to their nephew. Irrevocable trust refers to any trust where the grantor cannot change or end the trust after its creation. Trusts that benefit a charity, such as a charitable remainder trust or a charitable lead trust, are examples of this. Specific bequest refers to any specific property given to individuals in a will. So according to the will, Adam will receive his grandmother's estate and house, while his sister will receive her jewelry. Residuary estate refers to a testator's remaining assets once the other assets of the estate have been distributed to the named beneficiaries per the testator's will, and the executor has settled all of the testator's debts, taxes, or other expenses. If Adam's grandmother's car was not listed in her will, it becomes part of the residuary estate or the property left over. Next, we have power of attorney versus healthcare proxy. So power of attorney is an agreement between the principal and the attorney-in-fact that gives the attorney-in-fact rights to act in the principal's place. So there are several different types. General power of attorney allows agents to take any legal action their principals may take. Limited power of attorney allows the agent to only act and make decisions on specified activities, and only to the extent that the principal authorizes. Special power of attorney refers to a person delegating specified powers to an attorney to act on their behalf. So an agent with general power of attorney could open or close bank accounts in the principal's name. Granting someone the limited power of attorney could register title or sell a specific vehicle on the owner's behalf. And then someone with special power of attorney could be granted just for medical decisions or just to sell a specific house. Healthcare by proxy is an agent named in a healthcare declaration to make medical decisions for the person signing the document, who is the principal, when they are unable to make decisions for themselves. If Adam's grandmother became incapacitated and could no longer make medical decisions for herself, Adam could be named her healthcare proxy. And then lastly, we have a living will versus last will and testament. A living will is a written expression of a person's wishes to be allowed to die a natural death and not be kept alive by heroic or artificial methods in certain critical care situations. So for example, Adam's grandmother authors a living will, meaning that she wants to die naturally and free from medical care in some critical conditions. A last will and testament refers to the document written and signed by a testator that details how their estate will be managed and distributed upon their death and specifically refers to the most recent or final version of a will. Adam's grandmother's last will and testament list him as the primary beneficiary and manager of her estate and property. So here are some key takeaways that I got from this. So first is a guardian cares for the person and property, whereas a conservator cares only for the property. Second is a testator is the author of the will while the executor carries out the testator's formal wishes. And then there are several types of power of authority, which is general, limited, and special. And then these are my two references. Thank you.